This is the time set for a final hearing on the debtor's motion for an order approving bidding procedures for the sale of real property in the matter of iCap Enterprises, Inc., case number 23-01243. On behalf of the debtors, we have Julian Garuli.
Good morning, Your Honor.
Khaled Tarasi.
Good morning, Your Honor.
Madhu Pocha. Dakota Pierce.
Good morning, Your Honor.
And Liz Gonzalez. Jay Kornfeld on behalf of the Creditors Committee.
Good morning, Your Honor.
Assistant U.S. Trustee is Gary Dyer.
Good morning, Your Honor.
And also on behalf of the Creditors Committee, we have Amy Willig.
Good morning, Your Honor.
Is there anyone else on this call that I did not identify?
Hello, Your Honor. This is Lance Miller, Chief Restructuring Officer.
Thank you. This hearing is being recorded. Please proceed.
Good morning, everyone. I hope you're all doing well today. So we're here today on the Senza Kenmore sale motion. The debtors, in accordance with the bid procedures order I had entered late last year, conducted a sale process. I saw there were two bidders that participated in an auction, and based upon the notice that was filed late Friday, North Star Visions LLC was the successful bidder, and TD Holdings LLC was the backup bidder. Based upon there were no objections filed to the motion. Based upon the record before me, this seems to be a very straightforward matter where anyone who was interested had an opportunity to participate. Two parties did participate. The highest bidder is the prevailing highest and best bidder, and the debtors are prepared to go forward with that transaction. I've reviewed the red line of the proposed sale order and have just a couple minor comments, one cleanup and one marginally more substantive. But before we get to that, why don't I hear from counsel for the debtors?
Thank you, Your Honor. Khaled Tarasi of Buckhalter on behalf of the debtors. And I'm sorry, Mr. Garuli, were you? Okay, I'll proceed.
No, please.
Your Honor. Yes, thank you. Your Honor, we are pleased at the results of the auction to be before you today on the heels of a very successful auction. Your Honor summarized it very well. Just a couple of points to add is that Paladin and their real estate advisors, the Calderly Group and Pacific Realty Advisors, really did a tremendous job marketing this property and getting the topping bids on top of the stalking horse bid, which we estimate ultimately will net an additional $1.3 million to the estate, which is double what the stalking horse price originally was. So we are very pleased and proud of the marketing process of the team here. And as Your Honor summarized well, we did not receive any objections. And so obviously we would be willing to entertain any questions Your Honor has, as well as your markup of the sale order. So happy to hear that, Your Honor.
Thank you, Mr. Tarasi. Would anyone on the phone like to be heard relating to the debtors pending sale motion?
Your Honor, Amy Willig on behalf of the Unsecured Creditors Committee. The committee attended the successful auction and has reviewed the red line and does not have comments on the current form.
Very good. Thank you, Ms. Willig. Anyone else who would like to be heard relating to the pending sale motion? All right. Well, the court is prepared to grant the motion and approve the proposed sale based upon, again, the process that was implemented by the debtors with their advisors, the statements made on the record today, and then the absence of any objection. My two comments, and we reserve the right to have additional minor nicks and chambers, but the order generally looked very good to me. If the debtors could just fix two items. First, in paragraph B on page 3 of the red line, there's a parenthetical describing the backup bidder PSA and the backup bidder respectively. There's a stray closed parent after backup bidder PSA, so you've got your open parent and then your closed parent afterwards. So if you could just strike that second closed parent, very minor nit. And then paragraph 14, which is the backup bidder paragraph, which is, of course, completely acceptable and standard. I thought something might be missing from Clause 2, so the sentence authorizes the debtors to close the transaction with the backup bidder until the later of Romanet 1, the closing deadline set forth in the backup PSA. And then Clause 2 just says an additional 5 business days, and I was not sure what that 5 business days runs from or what that is after keyed to. So I thought it might make sense to just have some language clarifying what 5 business days from what, I guess.
Thank you, Your Honor. Khaled Tarazi on behalf of the debtors. Your Honor, that was we were trying to mirror the language there in the bidding procedure so that we weren't asking for or going for anything outside of what was already approved through the bid procedures, because I think, admittedly, the bidding procedures were a little ambiguous on that front. So we were taking it to mean an additional 5 business days from what is in the currently in the backup PSA, and for whatever reason, if we weren't able to close by then, just because that happened to be the outside date that was contemplated in the bidding procedures, that we would come back before Your Honor. But if Your Honor is willing to entertain a substantive change on the record today, we would ask that it be an additional 5 business days from, I suppose we would need from the notice of termination to the current successful bidder of the successful bidding PSA, if for some reason we are unable to close from whatever date that is. So we can craft something that's a little more artful, Your Honor, but that would be what our suggestion would be.
Thank you, Mr. Carter. Does the committee have any objection to that construct?
No, that's fine, Your Honor.
Does anyone else on the phone have any objection to what Mr. Crosby described? That sounds perfectly acceptable to the court. I just did not, I guess, catch this earlier in the stage, and just if I were to interpret this order, I really don't know what Clause 2 is supposed to mean. So I think just putting a little more meat on that is appropriate. And what you described, Mr. Crosby, sounds perfectly sensible to me. So you could just add that language and then make that minor nit in paragraph B with the straight closed parent, and then submit the order. We will get that process and entered.
Thank you, Your Honor. And for the record, too, we don't anticipate any issues closing the successful bidding PSA. So we look forward to doing that as well. But thank you, Your Honor.
Perfect. Thank you, Mr. President. Okay, so that's everything before the court today. I know I saw there was quite a lot of activity yesterday, and obviously we have a significant upcoming event with respect to the additional gift financing and the cooperation agreement between the committee and the debtors and the related proposed Ponzi findings. I have a variety of thoughts on that, most of which I think would be appropriate to wait and see what other parties in interest have to say in response. We will note on the docket for next week the debtor's pending motion to terminate the consulting with Mr. Christensen. As in, of course, typical practice, I will hear objections to the motion to shorten time on that in connection with the underlying motion. So I didn't hear Mr. Lesnick or anyone else on the phone for Mr. Christensen, but they should proceed accordingly, and advise their client in terms of if I grant the motion to shorten time, I'll be hearing that on the merits. If there's a good reason to deny the motion to shorten time, we'll have to figure out another date for the underlying motion. So I'm just going to hold and not shorten time on that today, but I anticipate that we'll be talking more about that next week. I'd also like to talk, and again, I didn't hear anyone on the phone for Mr. Christensen, and I don't know who else might be participating in the matters relating to the proposed Ponzi findings. To the extent there are any scheduling issues, I'd like to deal with them next week. I saw the proposed discovery process and briefing schedule that the debtors outlined, which made sense to me to the extent we're keying off of a March 27th hearing. Sometimes certainly discovery dates get worked out among counsel without the court's involvement. If any party in interest has a problem with the timeline that the debtor is proposing, that they need to make a motion, and perhaps we can talk about that next week to the extent appropriate. The one thing I will raise now that I think might be helpful, if we're talking more about the process here next week, is, I would like, so I'm familiar with the Ponzi issues, and it's my tentative view that pursuing this as part of a contested matter before the bankruptcy court is appropriate. When I was in private practice, one of the matters on which I worked was I was one of the attorneys representing a group of debtors called the Woodbridge Group of Companies in a bankruptcy case in Delaware. The debtors, the official creditors committee, and two ad hoc groups of creditor constituents in that case jointly negotiated and proposed a Chapter 11 plan that was predicated on, among other things, a finding that the debtors in that case had been operating as a Ponzi scheme. Some of the stakeholders in that case objected to the notion that there was a Ponzi scheme, and we litigated that matter before bankruptcy judge Kevin Carey. Judge Carey wrote an opinion finding that the debtors had indeed operated a Ponzi scheme and confirming a Chapter 11 plan predicated on that finding and that notion. And the plan included various settlements that resolved issues that stem from some of the legal principles that come into play when a debtor is operating a Ponzi scheme. In other cases, this issue comes up in other contexts. For example, kind of famously, Bernie Madoff was criminally charged, criminally convicted, and sentenced for operating a Ponzi scheme. I believe in litigation in connection with that case and other cases where principals have been criminally charged by the government and convicted of crimes. Typically, the mere fact of the conviction operates to establish the Ponzi scheme presumption based upon the fact that the burdens of proof and persuasion associated with the federal criminal process are significantly higher than the burdens of proof and persuasion that operate in the context of bankruptcy litigation. What I've not seen before, and I'm not saying there's anything wrong with that, I just, off the top of my head, have not seen it before, is what's being proposed here, which is kind of dealing with this issue, I'll call it midstream during the middle part of the Chapter 11 case. So I would just be interested to the extent there are any, obviously, written authorities or other precedents that anyone can point to in which this process has been followed. I'd be interested in learning more about that. Again, I'm in no way suggesting it's not appropriate to do what the parties have proposed here. It may be this is very creative and it's the first time doing it, and as I've written in some opinions, the bankruptcy process invites and encourages creativity of counsel. So if this is the first time procedurally kind of a midstream determination has been proposed, I'm happy to be the first person to take it on. But to the extent there's some precedent I can look to where this issue has been raised in a similar context, I would be interested in seeing it because, again, that matters in which I dealt with this issue in practice. It really came up in a different way. It's kind of all I'm inclined to say about this issue today, particularly since it's not before me, but since we may be talking about scheduling and the like next week, I wanted to put at least that comment on everyone's radar. But Mr. Willie, I don't know if there's more you think we need to do with any of this today.
Thank you, Your Honor. For the record, Julian Guruli of O'Melveny for the debtors. Your Honor, thank you for that commentary. As I think we all expected, I can tell that Your Honor has been through much or perhaps all of what we filed over the last 10 days or so. So thank you, Your Honor, for those thoughts. If it makes sense, Your Honor, I did have a couple of remarks. I know the debtors have been fairly active on the docket over the last few days, and I think sort of putting it together in context for the court and anyone else who maybe listening on the line might be helpful for the record. And then, Your Honor, my partner, Mr. Pocha, is on the phone too, and I heard Your Honor's thoughts about scheduling, timing, and the scheduling relief that the debtors have asked for in connection with the DIP in 1919 and Ponzi findings. Those make sense, Your Honor, but I would, at some point this morning, like to cede the podium to him in case he has any clarifying questions. Your Honor, if that's fine.
Yes, absolutely. And again, I don't know who's listening in, and this is, of course, a public proceeding, and whoever wants to listen in or get the audio after the hearing or read about it in the newspaper, if anyone from the press is on, we'll be able to glean what happened today. Again, I'm not intending on deciding anything substantively or even process-wise as it relates to timing, but I'm happy to hear further from you, Ms. Blue, and also from your partner.
Thank you, Your Honor. And I absolutely understood that Your Honor is not inclined to make any rulings today. But Your Honor, yeah, I would like to make a short presentation in light of what we have filed. Your Honor, we've reached a pivotal point in these cases. The debtors committed at the outset of the case to conduct an independent and thorough investigation of the facts and circumstances that led to the failure of the iCap business. That investigation was and continues to be overseen by Lance Miller, the debtor's independent chief restructuring officer, as well as the debtor's independent board of directors. The investigation, moreover, as the court is aware, has been undertaken with the full support of and in full coordination with the Official Creditors Committee and its advisors. The debtors, as the court may have seen, also supplemented their expertise in the investigation with the services of Jeffrey Kinrich, who is a certified public accountant and managing principal at Analysis Group with an extensive basis of experience in forensic accounting. Your Honor, while the investigation remains ongoing, one conclusion, as Your Honor has alluded to, is abundantly clear, and that is that during substantial portions of the pre-petition period, the iCap business was operated as a Ponzi scheme. The evidence on that front, not before the court today, but is overwhelming. Your Honor, some highlights. iCap used new investor funds, not legitimate business proceeds, to return money to earlier investors. Between 2018 and 2023, the iCap entities received some $286 million in investments from investors, $202 million in intercompany transfers, $55.8 million in loans, and only $34.9 million from legitimate business operations. That means that something like 84% of deposits were related to investments from investors or intercompany transfers, and only 6 to 9%, depending on how you calculate it, were related to legitimate business operations. The CRO's investigation has also found substantial commingling of funds, also indicative of a Ponzi scheme, as well as intercompany transfers that would routinely cascade through the family of iCap entities when interest payments were due on iCap issued notes. iCap investors were further encouraged to roll over their investments, either in the same fund that they were originally invested in or in a new fund. The investigation has also shown that iCap investors tended to receive lower returns. Later investors tended to receive lower returns than earlier investors, as the scheme apparently lost its ability to support itself. Your Honor, I know those are just a few of the highlights, if I can use that term. Obviously, the debtors have put much more in the record to be addressed at the appropriate time. Your Honor, for me, the question is always, right, so where do we go from here? And Your Honor touched on this a bit ago. It's clear to the debtors that recoveries for investors will be driven by litigation. As the court is aware, the debtors are in the process of marketing and liquidating the real estate portfolio, including the Senza property. But realistically, Your Honor, the value of that portfolio pales in comparison to the magnitude of the claims in this case. So the debtors will pivot to a different posture, increasingly focused on litigation recoveries. The debtors and the creditors committee have focused over the last couple of months on finding the best way to position these estates given what we have found. The approach that we have determined to pursue is now reflected in our filings. We can discuss scheduling and a bit of looking ahead, but I think it does make sense, Your Honor, for me to address some of those coming attractions in summary terms. As Your Honor mentioned, on February 23rd, the debtors and the committee filed a joint motion for supplemental DIP financing. The DIP is committed at $3 million and may increase to $5 million with the agreement of the lender and the debtors. The committee fully supports that financing. A supplemental DIP is critical to finance the next stage of the case and will provide essential liquidity and seed capital to fund litigation work streams. Importantly, Your Honor, that motion, is set for hearing on March 27th, and that is on regular notice. As Your Honor mentioned, a supplemental DIP is conditioned on this court making a finding that during the pre-petition period, iCap operated as a Ponzi scheme. Obviously, as Your Honor mentioned, this is a down-the-road issue, and we will also find, Your Honor, any supplemental authority along the lines you outlined. But our perspective absolutely is, Your Honor, a review of the evidence, including the declarations of Mr. Kinrich and Mr. Miller, lead to no other reasonable conclusion than that iCap was operated as a Ponzi scheme during the pre-petition period. Also, on February 23rd, Your Honor, the debtors filed a motion for approval of a settlement with the creditors committee, as Your Honor noted. That 1919 motion is also a critical piece of the case moving forward. As the court has heard previously, the debtors and the committee have been partners in this case, and the 1919 settlement lays the foundation for that cooperation in the future. In broad strokes, the 1919 motion allocates litigation work streams in an agreed-upon and efficient manner and is a product of arm's length and hard-fought negotiations. In addition, Your Honor, in terms of a preview to be discussed on the 12th, Your Honor, to be discussed on the 12th, the debtors last night filed motions affecting Mr. Chris Christensen and Mr. Jim Christensen. The first of these, Your Honor, is a turnover complaint naming the Christensens as defendants. The debtors seek turnover of company-owned laptops that the Christensens have thus far refused to hand over. The second item of relief relates only to Chris Christensen, and as Your Honor noted, is a motion seeking to terminate Mr. Christensen's court-approved consulting agreement with the debtors. As described in that motion, again, with the debtors seeking to have it heard on March 12th, but in our view, Your Honor, ample cause does exist for determination of that agreement in light of the nature of the pre-petition iCap business and Mr. Christensen's involvement, as well as the other facts and circumstances described in the motion. Just to close briefly, Your Honor, the debtors made a commitment at the beginning of the case to conduct an independent and thorough investigation regarding iCap and the allegations leveled against it. The debtors also made a commitment to prosecute these cases in a manner aimed at recovering the maximum amount possible for the benefit of investors. The debtors' filings over the last 10 days and the relief sought, importantly, on March 27th, represent a huge step toward the fulfillment of those commitments. With that, Your Honor, I'll pause for any questions, and as I mentioned, Your Honor, I would ask if Mr. Pocha has any questions, clarifications, or items that he'd like to discuss with respect to the scheduling or for anything else with respect to these items, I would like him to have that opportunity, Your Honor, if it's fine with the court. Thank you.
Very good. Thank you, Mr. Gurley. No questions from me. Ms. Pocha.
Good morning, Your Honor. Madhu Pocha, Melvin Myers for the debtors, and thank you to Mr. Gurley. On the scheduling of pre-hearing deadlines for the DIP and 9019 motion, Your Honor, the only additional point I wanted to raise is that we, on behalf of the debtors, would encourage the court to enter a pre-hearing schedule as soon as possible, just so that we can provide adequate notice to interested parties and just have an orderly progression that gets us from here to the hearing on March 27th. And it's our understanding that Your Honor is considering that. With regard to the motion to terminate, I have nothing further to add on the scheduling front. I know that's under consideration for Your Honor. But I do want to add to what Mr. Gurley noted with regard to the turnover complaint. We've also submitted a schedule that will provide for expedited briefing on the core issues that have been in dispute with regard to negotiations over the turnover of Mr. Chris Christensen's laptop and Mr. Jim Christensen's laptop. And just briefly, Your Honor, those two issues we believe are conducive to expedited briefing because they are legal in nature. The first issue being the question of ownership of the laptops. It's our position that they're unequivocally company-owned laptops, but that is an issue that can be resolved through briefing. And then the second issue is a question of whether any privileges attached to documents that Mr. Chris Christensen or Mr. Jim Christensen have saved on those computers. And we think those privilege issues could also be resolved efficiently through expedited briefing. So that's the thinking that informed the proposed schedule that we put forward last night for Your Honor's consideration, whereby we ask that any answer or response to pleading to the adversary complaint be due by March 11th. And then on behalf of debtors, we would file a motion for summary judgment by March 15th on the ownership and privilege issues, with any opposition due March 22nd. And in the interest of a speedy decision, we would forego a reply if that were fine with Your Honor. And, of course, we would be available for hearing if necessary. So unless Your Honor has any questions on the turnover scheduling issues, I have nothing further.
Thank you, Mr. Kocher. I'm reluctant today, particularly since counsel for Mr. Christensen doesn't appear to be on and doesn't have an opportunity to be heard, and all this was just launched late yesterday, to lock in a schedule. I will say we will be having a hearing next week. The court will need a good reason why we're not shortening time on the motion to terminate the consulting agreement. Absent a good reason, I will be considering that. If there are scheduling issues related to any of the pending motions of the adversary proceeding, I think that would be an appropriate time for me to hear from the parties some more about that. I will just say, I guess so it's on the record, in a case called, Supreme Court case called Bullard versus Blue Hill Bank, 575 U.S. 496, at page 505, Supreme Court Chief Justice Roberts wrote that expedition is always an important consideration in bankruptcy. And I've written several opinions highlighting what I've called the need for speed in bankruptcy cases, including in Chapter 11 cases. All of the counsel I'm aware who are involved in this case are experienced bankruptcy practitioners. When I was in private practice, there was a colloquial saying that bankruptcy practice is the equivalent of the emergency room of the legal industry, that when bankruptcy is busy, it's very, very busy. When it's slow, and things come and go and progress very quickly. For example, is one example of that in the famous Lehman Brothers bankruptcy case, bankruptcy judge Peck authorized the sale over some objections and concerns of the entire Lehman Brothers brokerage business to Barclays on 4 days' notice and on an expedited hearing. So anyone who's been a bankruptcy lawyer for any period of time, in particular in the Chapter 11 sphere, knows that things can often move very, very quickly. And that's what no one less than Supreme Court Justice John Roberts has indicated is supposed to be happening here. Again, I don't know who's on the phone today or who will be hearing this, but my operating assumption should be that the schedule, unless I'm convinced otherwise, the schedule that the debtors have proposed generally will be the schedule that will be followed absent good and sufficient cause convincing me that there's a fundamental problem with that schedule. Again, the need for speed in Chapter 11, as I've written about, and Chief Justice Roberts' admonition about the critical importance of expediting bankruptcy matters convinces me that we should be moving reasonably quickly. Again, I'm not deciding this today. If someone wants to bring a motion or argue what the debtors have proposed is inappropriately rushed, I certainly will consider that, but it will be done against the backdrop of what the Supreme Court and I have written about the need for speed in other contexts. So I know that's not exactly what you wanted. I'm sure you were hoping to have a order locking in a schedule today or this week. I'm not going to be doing that, but I think it would be risky for any party in interest to assume that the schedule you proposed will not be the schedule. And I think folks should govern themselves accordingly based on that backdrop assumption.
Thank you, Your Honor. That's all well taken.
Okay. Again, none of this is before me today, but if the committee would like to comment to that?
Thank you, Your Honor. Yeah, thank you, Your Honor. Jay Kornfeld for the committee. I would like to just add a little bit to what Mr. Gurley in particular shared with the court. The committee is, as Mr. Gurley said, fully supportive of the motion with respect to the supplemental DIP financing for the reasons that Mr. Gurley has laid out. We have worked in partnership with the CRO and his counsel, and as we have kind of articulated since the beginning of this case, the committee sees the case as one that is really about 1,800 investors that are owed nigh $250 million, and the ability and the efforts to generate recovery for those investors. We have seen the case while Mr. Miller is the CRO, we have articulated a view that effectively the case ought to be run as if Mr. Gurley or Mr. Miller were a Chapter 11 trustee, and in fairness to Mr. Miller, he has done so. He has included the committee in the critical efforts in this case. We have appreciated that, and we look forward to continuing to work with him and his counsel in that vein. With respect to the Ponzi finding issue, it is interesting to think about how that issue comes before the court and what it means. Obviously, the substance of that motion and how the court views it is for a later day. I will simply say, as Mr. Gurley has alluded to, the facts are really strong in this case. They support the conclusion that iCap, for the better part, if not its entire existence, was run as a Ponzi. That has significant implications for recovery by the investors in this case. If we waited until a plan, we would, in my view and the committee's view, be doing some damage to the litigation efforts that will, in fact, be the primary source of recovery for the investors in this case. The presumptions that flow from a Ponzi finding are important to the professionals, to the parties, and to the recovery aspects and prospects of this case for investors. And whether we are being fully creative and approaching this in a novel, never-before-approached procedural posture or not, I do appreciate the court's openness to considering as it comes before you. The reality is that it should be about what the facts say and not the procedural posture of how it's brought before the court. It is tied to the DIP financing, and for those reasons, the committee strongly urges that the court be open to considering it, as you have said you will be, we'll work with the CRO and its counsel to provide any additional briefing that we can in terms of it being raised in this procedural posture. But I did want the court to know that we've all considered this deeply, that there are even some tax implications which we might identify later for the court in briefing for potential investors that flow from a Ponzi finding that all grew out of the Internal Revenue Code changes due to the Madoff cases. We are pleased and appreciate that the litigation agreement, the cooperation agreement between the CRO and the committee does include the committee's litigation team in pursuing critical litigation matters, and we look forward to working with the CRO and his counsel to formulate an agreed plan of reorganization, I should say liquidation, that sets forth how we'll litigate into the future for the benefit of the investors. I simply wanted to state that in the record for the court, and we look forward to being in front of you in the better part of a month on these very important issues. Thank you, Your Honor.
Very good. Thank you, Mr. Kornfeld. I appreciate your comments. Mr. Dyer, I don't know if your office is getting in the middle of any of this, but if you have any thoughts you'd like to share, I'm of course, always open to hearing from you.
Thank you, Your Honor. Gary Dyer for the U.S. Trustee's Office. And yes, we are, on a couple of these motions, very concerned about due process issues, which I think the court is aware of and has alluded to. And I think that the process, even with facts that are as strong as being represented in the opening statements on these motions today, the due process, I think, is very important on how this procedurally goes. And I'm aware of the court's need for speed, opinions, and expedited, but I think that the structure by which, particularly the Ponzi findings, might be put before you, and the manner in which that process works, I think merits some deep thinking so that we don't have collateral attacks down the road. So there may be an objection from my office on this if we think that's necessary, but at this point in time, we have started the discussions with Mr. Gurley and Mr. Kornfeld about the issues that we see here, and we're not opposed to creativity, but the people who will become defendants in the litigation have some due process issues that I think we have to think through carefully. And those would be my sort of opening comments as we get to the March 27th hearing, at least as an initial hearing. Thank you.
Thank you, Mr. Dyer. I understand what you're saying, and I think some of what you're likely thinking about, the court's been thinking about as well. I'm not going to comment further on that today. I've kind of shared what I was prepared to share today, given my current thinking, but I understand your views and positions. So thanks, Mr. Dyer. Would anyone else on the phone like to be heard today regarding any of these matters? All right. Well, I anticipate we will be talking much more about this next week. So the calendar will reflect the motion to shorten time and the motion to terminate Mr. Christensen's consulting agreement. And I also anticipate we'll be talking about scheduling next week as well. Until then, as I've said, if anyone's listening and not commenting or hears this after the fact, I think it would be risky to assume that the court will necessarily be rejecting any aspect of what the debtors have proposed to. That may be what happens. It may be not what happens. We'll have to see. Until then, we'll get the order entered on the Senator Kenmore motion, and we will speak again next week. Thank you, everyone. We're adjourned.
Thank you, Your Honor.